Okay, everybody, we're live.
To call the zoning hearing to order, please. Can I have a roll call?
Yes, Jazz Preston,
Here.
David Brumbaugh,
Here.
Nathan Bunty,
Here.
Donald Haynes,
Here.
Terry Ann Dutrick. Here.
Thank you. Let's all rise for the pledge, please. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, first order of business is we're going to make an election of officers this evening. Anyone have any motions?
Do I nominate first?
Sure.
Okay. I would like to nominate Jazz Preston as chairperson.
A second. All those in favor?
Aye.
Motion carries. I'd like to appoint Don Haynes as vice chair for a motion.
I'll second.
All those in favor?
Aye.
Motion carries.
Thank you.
Thank you, everybody. All right, let's start this this session. So a motion to approve the minutes from February 2022, 2023.
I move to approve the minutes.
Do I have a second?
Second.
All those in favor?
Aye.
All right, let's start the hearing this evening. We need a verification of the zoning officer from Donna, the properties where they posted, and was the meeting advertised?
Yes, it was.
Thank you very much.
Okay, I will explain the procedure that the zoning hearing board will follow this evening, which is required by a state law called the Municipalities Planning Code. The first order of business for any hearing the board conducts is to determine the parties to the hearing. The applicant is a party to the hearing. The borough by law is a party to the hearing, whether or not the borough chooses to actively participate. The Borough Planning Commission is recognized as a party to each hearing if there is a representative of the Planning Commission present, and I do see a Planning Commission representative in the audience, so the Planning Commission will be a party. Other persons may seek to be recognized as parties. You do not have to be recognized as a party if all you wish to do is ask questions of witnesses or make a statement to the zoning hearing board. If you wish to preserve your right to file an appeal to the Lancaster County Court of Common Pleas, if you disagree with whatever the eventual decision of the zoning hearing board is, you must seek to be recognized as a party because only parties have the right to file an appeal. In order to be recognized as a party, you must have what is known as standing. Standing is a legal interest in the application that differs from the interests of all citizens in seeing that other citizens comply with the requirements of the zoning ordinance. After the parties have been determined, then the applicant will be given the opportunity to present evidence in support of the application. All of the applicant's witnesses must be sworn or affirmed. The members of the board or I may ask questions of the applicant's witnesses for clarification. Other parties have the right to cross-examine the applicant's witnesses, and then persons in the audience who have not been recognized as parties will be given the opportunity to ask questions. After all of the applicant's witnesses have testified, then other parties will have the opportunity to present testimony. Those witnesses will have to be sworn or affirmed. The members of the board may ask questions for clarification, and those witnesses may be cross-examined in the same manner as the applicant's witnesses. After all of the parties have given their testimony, then persons in the audience who wish to make statements will be given the opportunity to do so. Such people will also have to be sworn or affirmed and can be questioned in the same manner as every other witness. After all of the testimony has been presented, the board will close the record on the hearing. The board has the right to render a decision tonight or to take the matter under advisement and render a decision within 45 days after the close of testimony. The board also has the right to recess the meeting to have an executive session to deliberate if it desires to do so. The board will issue a written decision within 45 days of the conclusion of the testimony. The hearing tonight is a hearing on the application of D.L. Myers, Inc. concerning property identified as 336 Poplar Street, owned by TMMT Holdings. Is there anyone present to represent the applicant? Yes, sir, please state your name.
Mark Nickerson, real estate agent, Howard Hamel.
Please spell your name.
Mark Hendrickson.
And state who you're with again.
I represent Mr. Myers, real estate agent, Howard Hanna, York office.
Is there anyone who wishes to be recognized as a party other than the Planning Commission, which is automatically recognized as a party? Yes, sir, please come up to the microphone, state and spell your name.
Name Robert Emel, EMELROBERT.
And why do you wish to be recognized as a party?
I own the properties all around where he's purchasing currently, or looking to purchase.
So you're an adjacent landowner.
Yes.
Is there anyone else in the audience who wishes to be recognized as a party? Does the applicant object to recognizing Mr. Emel as a party? What, wait a second.
This is the actual applicant, Mr. Dustin Myers.
No, I do not object.
Okay, we can't have you representing the applicant and
The actual applicant.
a remote. how is someone on the remote going to be sworn or affirmed or testifying? And if he's the one representing the corporation, then why did you say you were the one representing
While I
the
was here
corporation?
present, we were told that this was okay for him to represent.
I was told by Paula that that was allowed. It's the same as a Zoom. Only we didn't know how to use the Zoom.
If, Ray, can you swear or affirm whoever that is?
Sir, could you just raise your right hand, please? You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Could you just state your name?
Dustin L. Myers.
You can put your hand down.
You might have to hold that closer to the microphone for us.
It's
Whatever you need.
Thank
very,
you.
it's difficult to hear clearly. Thank you.
I recommend that the board recognize Mr. Emmel as an adjacent landowner, as a party, and the board can do that by motion.
I'll move to recognize Mr. Elmo's party.
I'll second.
All those in favor?
Aye.
Carrie.
Mr. Emmel, can you come forward and state your mailing address?
Mailing address is 341 Chestnut Street, Suite 104, Columbia, PA 17512.
Thank you. Therefore, the parties to the hearing are the applicant D.L. Myers, Inc., the Borough Planning Commission, and Robert Emmel. The applicant should therefore present testimony in support of the application.
Okay. So I'm looking to purchase 336 Poplar Street to be able to expand my business. I own Batteries Plus in Lancaster and a few other areas in northern Maryland and Shrewsbury, PA. I plan on using this as a distribution point for my stores and local and regional customers. I've outgrown the space that I'm currently at, which is in Mountville, and I think this would be a great fit for me. Close proximity to Route 30, close proximity to my stores, and I would love to be a part of Columbia Borough.
Is that the entirety of your evidence?
Yes, I mean, to me, it's a basic transaction. It's a vacant warehouse. I need additional space, and I would like to purchase it for use of distribution of commercial off-the-shelf batteries.
I think that's the end of our testimony. Do we have any questions for the applicant?
Wouldn't there need to be exhibits presented?
Well, generally, it's the burden of the applicant to present evidence that the applicant meets the requirements of the zoning ordinance. The application itself doesn't sale lot.
There
With
were attachments with your packets that were
Mhm.
part of that application.
With the application, there was an agreement for sale, which demonstrates that the corporation has standing to make the application. There was an addendum to it, which indicates that there's a current lease that's being assigned for 10,760 square feet of the 13,160 square foot warehouse, and that the seller is transferring a security deposit to the buyer. And you have an application form that says the property is currently vacant. It appears that the application is for a substitution of non-conforming uses, but there's been no testimony about what the application material says is an existing use.
I did include a copy of a prior zoning hearing as part of that application, what it was approved of in 1989, which says assembly shipping of doors and specialties.
Well, the application says that there's a tenant, or the material submitted with the application says there's a tenant. The application says it's vacant. Mr. Myers says it's vacant. It's the applicant's burden to prove there's a substitution of non-conforming uses, not an addition of a use to a property that has a non-conforming use. I mean, generally, what would normally be done is that the applicant would come forward with testimony to demonstrate compliance with section 220-61 F, as in Frederick, of the zoning ordinance. That section states that it's a one-for-one swap, using more legal language, and there's a list of criteria that the applicant is supposed to present testimony concerning. And the entirety of the presentation hasn't addressed any of that.
Okay, well, I'm going to take some of the blame for this because I've been doing this 27 years and I followed the way that I've always done it. They were to provide an application along with, how many employees, how many, what are the hours of the.
It
I'm
is
not
the
sure.
applicant's burden to come forward at the hearing. It is not the zoning officer's burden to make the application.
No, and I didn't do that, but
So right now, we're at a hearing where it is the applicant's burden to go forward.
Yes, you did your part, Donna. You need his
And-
part.
yeah,
And the applicant had every right to consult with an attorney.
right.
And if the applicant did not choose to do that, that is not the responsibility of the zoning hearing board. At this point, there's no evidence presented other than it's for a commercial off-the-shelf battery distribution point for stores and regional customers. And that doesn't address the requirements of section 220-61F of the zoning ordinance. I mean, if the applicant wants to request a continuance to consult with counsel and come back to present evidence to the board, the applicant can do that. But if the applicant is going to rest the evidence on what the applicant has presented, then there's nothing that meets the zoning ordinance requirements.
So,
Okay, so I'm in the process of purchasing the building and I want to make sure the use has been approved. Am I responsible for what's currently going on within the property? I do not own the property. I want to purchase the property.
You are making an application to the zoning hearing board to substitute non-conforming uses. It is the responsibility of the applicant to demonstrate compliance with the criteria in the zoning ordinance to allow substitution of non-conforming uses. It's your burden to come forward and present that evidence, not the zoning hearing board's burden to find evidence. I mean, the zoning hearing board acts as a judge. You are the plaintiff, to put it another way, in a case. And when a plaintiff goes to court, the plaintiff presents evidence. And the evidence is supposed to relate to the law and what the plaintiff is requesting.
so
Understood, then we would have to request a continuation.
could I ask a question? May I ask a question?
It's up to the
Yes, you
board.
can. Go ahead.
Okay, so I guess basically what you're asking is him to compare what he's proposing to what was already there?
He would have to present his evidence to us to show us what he plans to do with the business that makes the difference to get the application approved.
I mean, if you look at section
Yeah, I don't have
220-61
my book,
F
so.
of the zoning ordinance, it puts forth standards and criteria for the substitution of a non-conforming use. And that's what every applicant has to present to the zoning hearing board when they are asking for that
Yeah.
special exception.
I've done that with variances, it just, not
It's-
special exceptions.
It's the same thing. Any applicant has the burden to present evidence. An applicant for a variance has the burden to present evidence of unnecessary hardship,
Right,
that the variance requested is the minimum to grant relief, etc. The applicant for a special exception has the burden to come forward and demonstrate that the applicant meets the specific and objective requirements of the zoning ordinance listed for that particular special exception. Section 220-61F has,
can I just run across the hall and grab my book? No, okay. Nothing.
that is the law. If someone wishes to disagree with me as to what the law is on special
No, I'm
exceptions,
not.
that's fine.
I'm not, I want to try to understand.
But section 220-61F, 2, 3, and 4 contain criteria that an applicant has to demonstrate that they meet. And simply stating that the applicant desires to have a commercial off-the-shelf battery distribution point for stores and regional customers doesn't do that. If the applicant wishes that this hearing be continued, the next meeting of the zoning hearing board would be on Wednesday, July 31 at 7 p.m. Is that the applicant's request?
Yes, that is the applicant's request.
If the zoning hearing board wishes to grant that request, the board can adopt a motion to continue the hearing to July 31 at 7 p.m. And if you do that motion, it does not need to be re-advertised because it will have been continued on the record.
I do, if I may ask a question, could I put a condition on that? May I?
What do you mean?
I mean, I think the applicant should show up in person.
One can't
Okay, I'm just,
compel that. It would
okay,
definitely be easier, but one can't make an applicant appear at all.
well, all right,
And if the applicant doesn't appear at all, then you just deny it. But
all right, thank you.
Do I have a motion on the floor for continuance?
I'll make the motion.
Do I have a second?
I second it.
All in favor?
Aye.
Motion to carry for continuance on July 31st at 7 p.m.
Okay, and if there's Mr. Emmel,
Can I ask a question?
use the microphone.
Do we have any idea of, what kind of trucks and how many per day?
Those are the
Yeah.
types of items that it's the
Yeah.
applicant's burden
I
to
know, I
present.
didn't know if
So-
you had any of that in the paperwork.
Wait until the next hearing, and then you will have the right to cross-examine the applicant.
Yeah, they'll bring forward the evidence for us to examine and look over, but they have to present it to us.
All right, thanks.
You're welcome.
Is there any other business on the floor this evening? All right, I'm going to ask for a motion to adjourn this evening.
I make a motion to adjourn.
Do I have a second? All those in favor? Aye. We're adjourned. Thank you for coming this evening.
Thank you.